Ramkishan Fauji, and two Calcutta High Court judges.
Suparna Kanjilal Chakraborty and
Suparna Kanjilal Chakraborty there, your lordship, Suparna Kanjilal Chakraborty was there, State of West Bengal there, etc. And other side was Mr. Mojumdar. He had taken the point that is not maintainable. His leader was there. On behalf of Subhendu Adhikari, they had taken the point that is not maintainable. It was not maintainable. Hold it. Now, this has been, two judgments have been held that the order passed in a writ petition which is criminal in character.
Criminal flavor.
Then they
let us patent. There is no.
Especially in the case of a quashing and etc. There are two arena appeals have been divided by the Honorable Chief Justice in another matter. Police inaction, transfer of investigation. That's a different issue. But when you are asking for quashing of the proceeding,
then you have a letter patent with us.
Yes. My lord, your lordships kindly. Your lordships will find from the Ramkishan Fauji itself.
This is. No. What is that clause?
Clause 15.
But also see clause 40 and 41. Just 1 minute.
Now you say that the judgment is wrong of the Subhendu Adhikari's matter. No, you say, I don't have any difficulties. But State of West Bengal, when will come in appeal, will say not maintainable. And when you will not get the order, you will say I am not maintainable. But I have no difficulties. But once for all, it has to be decided. Because of Subhendu Adhikari, it is not maintainable, it will be held. But because of the state, it will be maintainable. That cannot be the criteria. That time it will come. You are the persons who have said this. All you are the persons who have curtailed this. Well, fundamentally, I feel that there should be an appeal. And every time it is not possible to go to Supreme Court, that I feel it. But you have called, you have curtailed this. Appearing against the state, that time you are all bossy for us. 15 councils will come from Delhi, here, not maintainable, etc., etc. Madam, kindly come to paragraph 17 of the Ram Fauji's case. First.
No, I just, Mr. Bandyopadhyay, as my character goes, I want to look at the provision of law first. I will go to the judgment.
No. Here the judgment this has been quoted. That's the reason. Exactly, that has been quoted.
Clause 15.
Clause 15.
Yes. Give us 30 seconds. Please.
No. Where is it?
There is a typographical error. I do not know from where you got it.
From internet we got it.
No, that is what is the problem.
21.
Absolutely typing mistake in clause 15 itself. It should be with error. What is this?
We shall bring it, Lord. We shall bring the book.
Where it is quoted,
kindly come to first your lordships, just Ramkishan Fauji, first your lordships come to paragraph 17, Lahore High Court's.
So that is the.
Then the Supreme Court has said is a parameteria. Kindly read below paragraph 17. Appeal to the High Court from judges of the court. And we do further ordain that an appeal shall lie to the said High Court of Judicature, allowed from the judgment not being a judgment passed in the exercise of the appellate jurisdiction in respect of a degree or order made in the exercise of the appellate jurisdiction by a court subject to the superintendence of the said High Court, and not being an order made in the exercise of the revisional jurisdiction. May take 1 minute. See clause 23. Just similar clause 23 of the latest precedent of our High Court. There the question lies, according to me. Similar to, kindly excuse me, only one. Extraordinarily original criminal jurisdiction.
No.
23?
23 is a jurisdiction as to the persons.
Jurisdiction as to person. 22.
22 is ordinary original jurisdiction.
Anyway, but kindly see 23, next 24, possibly.
24 is extraordinary or original criminal jurisdiction.
Original criminal. Can you read this? I don't know why it's not telling. It's the latest one. I don't know. And we do further order that the said High Court of Judicature at Fort William in Bengal shall have extraordinary original criminal jurisdiction over all persons residing in a places within the jurisdiction of any court, now subject to the superintendence of the Sardar Nizamut Adalat.
You are reading something else. It is not there in the book.
This is
right, sir. আমরা রিলাই করছিলাম. This is not correct. এই বইয়ে
can I
Please look at that 24.
Yes, yes.
শান্ত থেকে সব আসছে এগুলো তাহলে
Look at this 24. You have handed over. Devani Sadar Adalat
চেঞ্জ হয়ে গেছে.
is omitted.
হাইকোর্ট হয়ে গেছে.
I tell you, Mr.
all right, can you just see? Just 24 is extraordinary criminal, original criminal jurisdiction. আচ্ছা বই আছে দিয়েছো
Yes, yes.
extraordinary criminal jurisdiction. ঠিক আছে? On way to further order that the High Court of Judicature at Fort William in Bengal shall have extraordinary original criminal jurisdiction over all persons residing in places within the jurisdiction of any court now subject to superintendence of the said High Court shall have authority to try it at his discretion any such person promised for consider. Now 25. And we further order that there shall be no appeal to the said High Court of Judicature at Fort William from any sentence or passed or made in any criminal trial before the courts of original criminal.
That is what I am saying. That has been abolished subsequently. What you have better experience than all of us. Being a more veteran in the profession. Previously, the High Court had a power to conduct a session trial. So that was there. They used to.
I know that. I know
Last one I saw, you must have seen more.
No, one was
Only one.
4 years.
So that is, you saw also, and we saw also jury trial and all, everything was there. Later on, this has been abolished.
Correct.
That has been taken to district court for that. So these were the provisions initially that the High Court was exercising the original criminal jurisdiction.
Correct.
But the difficulty I think Ramkishan Fauji is there. There is no doubt about it. But the trouble is because, as you know,
Yes.
very clearly
Correct.
to have a proper
Correct.
all of you.
Correct.
But Justice Radhakrishnan, in a subsequent judgment, that is in Palpal Kumar Agarwal,
Correct.
he considered Ramkishan Fauji.
Correct.
What troubles us in two things? Please enlighten us on that.
Yes.
He interpreted Ramkishan Fauji in a particular manner. And ultimately arrived at the conclusion at paragraph 27. He says that yes, the appeal would not lie, but in what situation? The situation is if there is a quashing of the criminal proceeding, or by virtue of an order passed by the court to initiate a criminal proceeding, then in these two situations, appeal would not be maintainable. Means only against the final order quashing the entire proceeding.
Right.
Not against an interlocutory order which is passed. And then paragraph 28, he held that appeal is maintainable.
My lord, kindly read. Paragraph 27.
27.
We have no disagreement. We have no disagreement with the proposition of law propounded in the aforesaid decision.
Yes.
However, in the facts of the present case, the order of the learned single judge neither resulted. Correct. Neither resulted in initiation of the criminal proceeding, nor in quashing of a criminal proceeding. The facts of the instant case from the facts of the Delhi case discussed above. Now, this is 28. For the aforesaid, we hold that the present appeals are maintainable and not barred by clause 15 of the latest patent 1865. Now let kindly come. Then one has to take which judgment I will take. Ramkishan Fauji has been clarified. Kindly come. Then
Paragraph 22. And please come to paragraph 22 of that
the
judgment.
facts in the case of Ramkishan Fauji are different from the facts in the present case. In that case, the learned single order had a consequence which was clearly criminal in nature. The learned single has opined that the recommendation of the Lokayukta for registration of FIR against Ramkishan Fauji deserved to be quashed and accordingly quashed the same and also quashed the action taken pursuant to such.
This is what a distinguishing feature he brought. That suppose in the instant writ petition, I am telling you, there are two situations that may come. Either the court will dismiss the writ petition saying I am not going to quash, or the court may quash it, saying that I am quashing the FIR. There are two situations because first prayer is like that, quashing of the proceedings. So either of these will come. Suppose just out of sheer exchange or view,
My lord,
if he quashes it, then Ramkrishna Fauji says no appeal lies.
correct.
But if he refused to quash, then the Justice Radhakrishna's view was that it does not create a fetter in maintaining the
Correct.
because in Ramkrishna Fauji, the criminal proceeding was quashed. And thereafter, this is what a distinction in paragraph 27 comes. Please correct me.
Yes, my lord. Yes.
My mind is still open.
Correct. I understand. I will tell you, Lord Sir, I correct. Finish. My lord, can I start now? See, let me pass
on a maintainability, Mr.
No. I tell you, my lord. Let me first express my view, then I will come. But my view is this. My personal view is this. Of course, take it as a personal view reading in this.
Then let us.
My personal view. No, doesn't matter. Let it. That's I am talking about law. I am talking about law. I am not talking anything. Every lawyer has his own reading. Every judge has his own reading. Interpretation of the things differs from man to man. Today Ramkishan Fauji is there. Tomorrow any other bench 5 years Ramkishan Fauji is not correct law. These are we have seen that. In an article 226 is a right for establishment of the fundamental right or constitutional right. Breach. Broadly I am talking about, broadly. This is available to High Court. Very recently I did one matter. I am taking cue. I will tell you the sentence which has been used by the Supreme Court in that matter. High Court entertains 226 is the original jurisdiction. 226 civil, criminal, etc. Now, last few years, fortunately, unfortunately, a practice has been developed because of Arnab Goswami's case, entertaining quashing of the proceeding, granting bail, and Calcutta High Court has passed so many orders. No coercive stays, other way the bail is given, anticipated bail is rejected. Now the point, now it has come. Earlier it was not there. Earlier it was very difficult in Calcutta High Court to entertain a writ petition is in very rarest cases is entertained when seeking for quashing of the criminal FIR, etc. Because everybody, if you have a case, go to 482. But anyway, for last 3 years, a practice has been developed in Calcutta High Court with great respect to all the judges. Even that matters have not been settled, decided as yet. 3 years, 4 years, one is enjoying. Now the point, the interim order, don't arrest. No court system. That means what? You are exercising the power of the anticipated High Court jurisdiction. Therefore, question is not other way it can be done or not. It was not there. Now, although High Court under Article 220, there is no bar to entertain a petition questioning the FIR. No, there is no bar. Bar would be exercised or not, power would be exercised or not is a different matter, but power is exercised. Now, interim order has been passed in a criminal proceeding I mean quashing of the proceeding, when a writ has been entertained, interim order has been granted. Against that, when an appeal is filed, Calcutta High Court is saying no appeal is maintainable. Granting an interim order, non-granting an interim order is equally without standing on the same footing or any direction has been passed. Question is whether in an interlocutory stage even an appeal is maintainable so far the criminal jurisdiction is concerned. When you are exercising power, but my personal view is, it should be, chance should be given to the litigants. Very recently, I did a case on the basis of a Supreme Court judgment challenging the order of the National Green Tribunal, and the Supreme Court has already decided, yes, National Green Tribunal's order, writ is maintainable. Writ is maintainable. Reasons have been given for that. One of the reasons I am saying, that it is not possible for the peoples of the country to run to the Supreme Court and file an appeal. Question is really it's a alternative remedy, efficacious remedy or not. Well, leave aside everything. Higher state has come up as an appellant. Earlier cases, very rich persons, powerful persons, Sugandhu Adhikari had prepared an appeal. Anyway, but every litigant cannot come. It is not possible for every litigant to go to the Supreme Court. There are poor and poorest people are also there. Because of the law which has been laid down in Ramakrishna Fauji and subsequent thereafter, it has created a bar. Now, let me read the Ramakrishna Fauji's case. Leave aside my personal view, now I am coming. What is the views have been expressed by Ramakrishna Fauji's case? Let's read it kindly.
Only one query on that. I also want your reaction or argument on that point also. A judgment of the Supreme Court is interpreted by a coordinate bench of the court in a particular manner. Now, subsequent coordinate bench, if he thinks that interpretation does not appear to be correct, then what would be the course? Whether there are two things: either the other coordinate bench is bound by that interpretation or understanding or explaining or explanation given for that judgment, or he can take a dissenting view on that. That appears is like that. So what is your reaction to it? Because this Gopal Kumar Agarwal judgment, I really just now read it, 27 and 28, that really...
but read Justice Talukdar's judgment. Justice Talukdar's judgment.
No, another avenue will come because this is the earlier judgment of the bench, and Justice Talukdar's judgment
Talukdar's judgment
is a latter one.
Yes.
Now, this judgment was taken into consideration by Justice Talukdar.
Of course.
And now, suppose if the Justice Talukdar has taken a dissenting view to it, what would be the proper course?
The proper cause below kindly I see.
Or I do not know whether he has taken a dissenting view.
No. May I clarify? No, please. Mr. Mujumdar, I know little bit of these things. I know little bit of things.
No, I'll appear.
Let's clarify the position. Every time all you... Lord, kindly see, against the judgment of the Justice Talukdar, SLP was preferred by state. That was not entertained. There are two reasons are there. What has happened, my lord, against the single bench order, judgment of justice, that was single bench, justice, single bench, appeal was there preferred, and also against the order of the learned single judge, special leave petition was filed. But incidentally, that special leave petition against the order came up before the Supreme Court. And I had the privilege to argue the matter. First matter that came up, my lord, and the Supreme Court said, all right, we are not going into the merits. What we are doing, we are saying the single bench to decide the matter expeditiously. Matter is coming up within few days. And actually agreed to that, all right. Disposed of. When the appeal court's order, this SLP was filed, Supreme Court said that since we have already said the matter should be expeditiously heard, we are not entertaining the SLP. This is the two matter. Effectively, on merit, it has not been decided whether the judgment of the Justice Talukdar division bench presided is correct or not decided by the Supreme Court. Now, your lordships, if you want to differ, or refer to the larger bench, I have no difficulties. But again, I am saying, I will be happy. I will personally be happy. But I have to discharge my duty. I will be discharging. Because I appear for the poor litigants of this state in number of matters. It is not possible for to go there to up to Supreme Court. That I understand. Anyway, I have to discharge my duty to your lordships. Not come to Ramkishan Puri. First, let me read it. Again. First, my lord. I got 4.
Civil writ.
Civil writ
Petition.
asking for quashing of the order of the locautor to initiate the proceeding. That was the order. Then we will kindly come to paragraph 8. Questioning the sustainability of the order passed by the division bench, Dr. Rajiv Dhawan, learned senior counsel, has raised a singular contention that the LPA preferred before the division bench was not maintainable in as far as learned single judge had exercised criminal jurisdiction. The point is not whether the single judge had exercised criminal jurisdiction or not. Now, we are kindly come. Here the two questions was that civil, etc., civil criminal. I am skipping up. Then we have 227 maintainability, etc. Kindly come to Millard.
Up to paragraph 16.
Yes, 16. The image needs to be immediately cleared. In the instant case, we are really not concerned with the nature of the post held by the local or upulakato. We are also not concerned how the recommendation of the state authorities is to be challenged and what will be the procedure. Therefore, as has been held by this court, neither the local nor can upulakato direct implementation of his report, but it investigates and further investigates. If it is found a public sector committee criminal prosecution can be initiated. Having discussed the aforesaid at this juncture, refer to clause 10 of the latest patent. As well as the Punjab and Lahore High Court is absolutely opposite. It is as follows. And we do further order that an appeal shall lie to the state High Court of Judicature and Lahore from the judgment not being a judgment passed in the exercise of the appellate jurisdiction, in respect of a degree or order made in the exercise of the appellate jurisdiction by a court subject to the superintendence of the state High Court and not being a
Always the replica of clause 15.
clause 15. They have said so. Now,
18 is made.
on a plain reading of the aforesaid clause of later patent, it is manifest that no appeal lies against the order passed by the learned single judge in exercise of the criminal jurisdiction.
So I'm saying that is a
Thus, kindly pause for a moment here. Kindly excuse me. Kindly pause for a moment here. Granting of an interim order, not granting of an interim order in a question of FIR quashing. Whether the power is being exercised by the single judge in criminal jurisdiction or not. If you hold no, it is not a criminal jurisdiction, appeal is maintainable. If you hold no, it is a criminal jurisdiction, then appeal is not maintainable. Nature of the order is not what is the nature of the order is not concerned we are. Concerned we are whether it is exercising the power in a criminal jurisdiction or not. You go there, appear, you go not to go, that's not, we are not concerned about that. We are concerned what jurisdiction. If you hold no, it's not a criminal jurisdiction, appeal is maintainable. But if you agree with this, yes, it's a criminal jurisdiction, then appeal is not maintainable. Does the question that is required to be posed, whether learned senior is obtaining factual matrix as exercise criminal jurisdiction or not? Paragraph 18 has the question has been made. How? Take the factual matrix of the case.
Come to then straight away come to paragraph.
I just kind. Lordship will rise now.
This is what you say is again 22, small paragraph. This is what you say. Paragraph 22.
From the aforesaid authority, two aspects of the absolutely clear. First, where an appeal is not excluded against the judgment of a single judge of the High Court, an appeal would lie to the division bench. And second, if the appropriate legislature has expressly or by necessary implication not taken away right of appeal, the appeal shall lie from the single judge under clause 10 of the latest patent to the High Court.
So if there is a embargo, then it will not. If there is no embargo, then the right should be considered.
Now, Millard, Lordship rise, and I think time.
Not that. If you continue, we can continue.
No, I don't mind.
On the medical advice, I think more than that.
No, I don't mind. I am not saying, but they have come, that's the reason. I have nothing to say personal, Millard, that whether rise, non-rise, that's your Lordship's matter.